Please introduce yourself.
My name is Paul Wallace. I'm with the Delaware Attorney General's office.
And what is your position in the Delaware AG's office?
I serve now as the Chief of Appeals for the state of Delaware.
And is that on the criminal side?
Yes, I do all criminal appeals.
And how long have you been a prosecutor?
I've been a prosecutor for 20 years, a line prosecutor, actually trying all types of cases, including homicides, for 18 of those years. In the last 2 years, doing wholly appellate work.
Mm-hmm. And have you had the occasion to argue life without parole for juvenile cases before your highest court in Delaware?
I have. Actually, in the last 2 years, I've argued at least 3 of those types of cases and also prosecuted them at the trial level.
Right. And are you aware of the movement to abolish life without parole for juvenile killers?
I am, and I think one of the most disturbing things about both the litigation I've seen and that movement itself is this idea that it is simply unconstitutional.
Well, let's talk about the constitutionality of it. Take us back quickly to our forefathers and then back to common law. How did the Eighth Amendment even come about?
Well, the Eighth Amendment, first at common law. Before then, when we dealt with juveniles, as long as they met the mental health standards for criminal responsibility, were treated like adults. The Eighth Amendment then included into the United States Constitution, came from English law, basically to prohibit torture and cruel punishments. What it's turned into, however, is a claim mainly by people on the defense side that it prohibits other types of punishments that aren't necessarily cruel or unusual.
Is there a difference between the way our Supreme Court has dealt with capital cases or death penalty cases in terms of sentence and proportionality and all other non-death penalty cases?
Actually, there's a huge difference, and it's a difference that the other side has latched onto or has really ignored. What they try to do is take death penalty cases. Death penalty cases mean that when you have the most serious punishment, you should have individual decisions about the person, the crime. Non-death penalty cases, cases of all other types of sentences, the Supreme Court's dealt with one particular way and said, as long as the crime meets the punishment, we have no Eighth Amendment problem.
So in those cases, the courts don't even look at the individual offender. They only look at the authorized punishment that the state legislature laid out in its books?
Right. In fact, they specifically don't look at anything other than that. Interestingly, the same author of the opinion that is used by the other side now sets forth that rule that's most accepted, and that is that unless there is some, they call it gross disproportionality, some grave difference between the crime and the punishment, there's no place for federal review of that sentence. In fact, they leave to the states to determine what's the appropriate punishment for any particular crime.
Now we hear, and we've heard over the years, this phrase that death is different. What does that mean to a constitutional lawyer such as yourself who's practicing appellate law?
Well, interestingly, most often you hear that from the other side, saying death is different and therefore we should have more rights. Death is different does mean that, but it also means this in this particular circumstance. A death sentence is far different than a sentence of incarceration. And that's why so many states have said that incarcerative sentences, life without parole sentences, should be used for the most serious juvenile offenses.
I see. Now, we know that 43 states and the District of Columbia and the federal government authorizes life without the possibility of parole for juvenile killers and violent teens. Does Delaware?
It does.
And what types of cases does Delaware authorize that sentence for?
All Class A felonies, which are murder, rape, and actually attempted murder. Other than that, however, you cannot get a life sentence as a juvenile. The only other circumstance in which you could even get life without parole in Delaware is if you were a habitual criminal offender, somebody in a 3-strike situation, which no juvenile would ever face.
Paul, what's the danger of applying the language and logic of the Roper decision the 2005 Supreme Court case which abolished the death penalty for juveniles to all non-death penalty cases. What's the harm here?
Well, the harm is great, actually, because from a legal perspective, when you have one set of cases that says there's this set of rules, we look at everything related to it. The death penalty case, where it's appropriate, that sentence is irrevocable. But then you try to take those rules and you apply it to a set of cases that the Supreme Court has never said it should be applied to. What it will do is allow the federal courts, state courts, to look at every legislative act that sets a sentence and determine whether they individually believe that it's appropriate. When the Supreme Court drew that very dark and stark line between those two sentences, they did it for a reason. That is to say, when the crime matches the punishment, when there is no huge difference between those two, when there's no gross disproportionality, we should stay out.
So in other words, defer to the legislative wishes.
Exactly.
The view of the people.
Right, exactly. And when it does, in fact, Chief Justice Rehnquist said, then when you don't do that, what you do is basically take the democratic process out of making laws. We can't allow it in this one area and then disallow it in others. So this would be the first step toward saying that individual states can't look at crime and punishment and make their own decisions as to what to do. That can be a real problem. That can allow courts to overlook sentencing in all circumstances.
You have clearly fought for justice in your 20-plus years as a prosecutor. What effect would this constitutional end run, if successful, have on victims and victims' families?
That's one of the worst parts of it. For myself as a prosecutor, when you look at people being re-victimized by having to readdress a sentence time and time again, it becomes all the more difficult. I've been at pardons hearings, I've been at parole hearings for families who have had great losses. And each and every time you go back to try to look at that sentence again through a parole hearing, which somebody may not have any right to, they have to relive that crime. They have to suffer that loss all over again. And it's a very terrible process for them.
Now, you have had personal experience with the Donald Torres case out of Delaware, which you argued as an appellate lawyer before the Delaware Supreme Court. Tell us a little bit about that case.
Well, that case involved a 14-year-old who had made a decision to kill basically a family of 4. What had happened was Donald Torres became friendly with the family. He became friendly with the family because what he first did was he did some criminal mischief against their car. The father, who had a difficult childhood himself, said, you know what, I don't want you to get in trouble, and actually took him under his wing, had him do some work around the house to pay back the damage, even went fishing with him.
This is Mr. Gott.
Mr. Gott, Harry Gott was the father, Jennifer Gott was the wife, and there were 2 children, a 3-year-old and a 1.5-year-old. What ends up happening is that Mr. Gott scolds Donald Torres once about trying to teach the young boy, his son, John Gott, how to light matches.
When you say scold, did he hit him or do anything mean to him, or just said, don't do that anymore?
No, literally just a verbal scolding.
Okay.
What he did was Donald Torres came back one night and sought revenge for this scolding. And he spread kerosene throughout the bottom of the house, around the stairwell, and lit it. He later told the police and told his own mother that he knew what he was doing and he knew who was in the home.
Well, when he lit it on fire, what happened?
After the fire had started, he went outside and he watched. He watched as Harry Gott came downstairs screaming, basically just in his underwear, outside the house, and screamed for help. He went back into his house, Mr. Gott did, to try to save his family. And unfortunately, when he was found, his body was in a position where he was trying to shield his wife from the flames. She had perished. The 2 young children were close by on the floor in their parents' bedroom also trying to get out of the fire.
So he killed 4 people?
He did kill 4 people. And then after he killed those 4 people, he bragged to his friends about it. He hid from the police basically anything that he did. When he was questioned, he first denied it, and until they brought basically to his attention the fact that they knew what had happened and things like that.
Well, was he
finally
represented by a decent defense attorney, I hope?
He was. He was represented by really some of the best defense attorneys in Delaware. You know, the Donald Torres case is one where really you see the importance of this particular issue. There's no doubt as to his guilt. There's no doubt that he did it himself. It wasn't a situation where somebody else brought him into it. There's no doubt that 4 people lost their lives. Also, under Delaware sentencing, he should get consecutive sentences for that. He got 4 separate life sentences. If, in fact, when you have absolutely no doubt as to guilt, by the way, he also was put through the juvenile system as far as a Superior Court judge determining that he should be tried as an adult instead of a juvenile. So he also had the benefits of that.
So an independent judge took a look at all the facts and circumstances before making a decision to send him to adult court.
Well, he was actually in adult court, and the question was whether he could go back. And a judge applied Delaware law, said no, there is sufficient evidence for him to stay here. The crime calls for him to stay here, and therefore he did stay in adult court. He was tried by a jury and found guilty beyond a reasonable doubt. He, in fact, has had numerous appeals after that, attacking his sentence and things like that. Some of which
have a problem with that. I mean, that's part of the criminal justice system.
No, not at all. Really, the only problem we ever had was with this 4th attempt at what's called post-conviction release, this 4th appeal down the line, which said, well, his crime is cruel and unusual. His sentence is cruel and unusual. It's unconstitutional.
What was it about the advocacy on the other side that you found to be a little unsavory?
Well, I think the initial motion that was filed in the trial court was a little bit disingenuous as to the facts. Basically, I laid out the facts for you. We did that in our briefing. What we saw from them was one sentence that said Donald Torres, when he was 14 years old, was involved in the arson death of 4 people. Well, that really minimizes exactly what he did. And unfortunately, as I've done more research, as I did research for the Torres case and other cases, you see that happening in the advocacy. There's a couple of problems with the advocacy. One,
well, I mean, I've been a criminal defense attorney. You've got to play your best hand. What's wrong with that?
Well, if on one hand you are saying that we need to look at these individuals and look at their crime before we can determine what the sentence is, then you also need to look at the entirety of the crime and their responsibility for it. In looking at their responsibility in Donald Torres' situation for this, there was no doubt that he should be treated as an adult and sentenced as an adult. So you have to, one, ensure that you're keeping a constant message about it. The other problem, of course, is that they speak as if it is a simple matter of it clearly being unconstitutional by applying law that's never been applied to this type of case.
So in other words, the law in the death penalty arena and talked about in Roper.
Exactly. You are taking basically law that's strictly to death penalty cases and trying to apply it where it does not apply. And they do it in terms by saying he's been sentenced to, quote, die in prison. That's not true. He's been sentenced to live in prison and hopefully make whatever it is he can out of it, just as most prosecutors would hope any person who is sentenced to life would do, to be productive within those confines.
Now, we have featured the Torres case in our new book, Adult Time for Adult Crimes, on page 46, and you can actually hear the oral argument that you made before the Delaware Supreme Court, and you can see that in a footnote to our paper. Was there anything about the argument that the other side put forward that the justices in the Delaware Supreme Court found highly skeptical and you needed to rebut?
Well, yeah, there certainly was. Part of the problem is that many of these appellate arguments end up being pitches as if to pass a law. That's not what a judge's job is. And in part, what we saw was that there was really very little discussion about the details of what's going on in this country. Specifically, how many states have this type of law, how often it is used. In truth, it's used very rarely because luckily there are very rare cases in which this type of sentence is appropriate. But when it is appropriate, it needs to be used. It is available, however, in most states to ensure that those states can sentence accordingly. That was wholly glossed over, and I spent much more of my time trying to clarify exactly what the state of the law is, both legislative law and case law, relating to these particular sentences.
Did the issue of international law, or whether we're in compliance or out of step with the mainstream of the world, come up in those arguments, or have you heard that from the other side?
Certainly we've heard it, and it gets drawn in again from the death penalty law and the death penalty cases. In my own personal experience, very little. We spoke much more about what's going on in the United States and some of the biology arguments that are made, which, interesting also, during research later on, we found that the scientists that they were citing were not retracting it, but simply saying, we never expected that anyone would try to apply what were really science findings to public policy like this. And they really aren't even comfortable. Some of the NIH researchers said, we're not comfortable with saying brain biology can be associated to behavior as much as a Supreme Court case should.
So what you're referring to is the notion put forward by the other side that brains in teenagers, especially younger teenagers, are not sufficiently developed such that they should not be held accountable for their crimes?
Exactly. They took scientific findings that were not to be applied to crime and punishment, but to wholly other areas, and tried to say, well, it's clear, science says, that these folks should not be held accountable. That's not what the scientists would say themselves. In fact, most of them are uncomfortable with trying to make that degree of correlation.
The last thing I want to talk to you about is the legislative efforts around the country to overrule this. You have worked on legislation while you were in the AG's office in Delaware. What have you seen, if anything, regarding the efforts by the anti-incarceration activists to get state legislatures to overrule life without parole for appropriate juvenile killers and violent teens?
Luckily, we have not faced that in Delaware, but I have, just through the research and the work that I've had to do to try to determine what other states were doing, seen it. And it's the same level of advocacy, unfortunately, that the whole story is not told, even either the whole factual story about these particular killers and their crimes, or the legislation. Most importantly, from my perspective, both as an appellate attorney, but also somebody who served as a legislative attorney for about 15 years for our Attorney General, is that holding up right away, it's unconstitutional. Nothing chills public policy discussion than a lawyer saying, what you want to do is unconstitutional, or what you have done is unconstitutional.
Well, certainly there are things that are unconstitutional.
Certainly there are. If it was in the Eighth Amendment perspective, if this was subjecting these juveniles to torture or other circumstances, or even not following federal law about the conditions under which they're kept. For instance, ensuring that they're not kept just in adult prisons, but that they're sight and sound apart from adult prisoners. Everybody I know who's involved in this believes that juveniles who are incarcerated should be treated with basic human dignity and should be followed all those laws. The question is how long they serve the sentence. And that's where it's most important in this constitutional debate, because Roper, the very case they turned to, depended on the fact that life without parole was available in striking down the death penalty for juveniles.
So Roper actually counts on the availability of life without parole to make its main holding.
It does it in so many words. It specifically says that for a young offender, it is enough of a deterrent sentence to ensure that that severe life without parole is imposed.
And in your research and advocacy, has any state Supreme Court or any federal appellate court struck down life without parole as a constitutional matter for anyone brought before those courts?
No.
So in other words, every state Supreme Court and every federal judge who's looked at this as a whole has determined that the state legislatures are solely within their discretion to find these sentences and put those sentences out there.
They've always upheld the sentencing laws. Now, have there been some challenges in other places based on specific circumstances? Absolutely. But the laws themselves are solid. The principle itself that a juvenile life without parole sentence can be used in those rare circumstances that they're needed is absolutely on solid constitutional ground.